Hello everyone, today I'll be sharing another legal story with you. So on 23rd August 2025, the Supreme Court was dealing with the KKD Pandian versus S. Tamil Selvi case. So in this case, what happened was that the complainant made allegations against the accused that he has taken 2.30 lakh from the complainant, okay, on the promise that he will get him a job as a clerk in the school, okay, but the accused was unable to fulfill his promise, right, and he issued a check in the favor of complainant for the repayment of that 2.3 lakh rupees, okay, but when the complainant presented the check, it got dishonored due to insufficient fund, right. Thereafter the accused got convicted by the trial court regarding the dishonor of check, okay, but in appeal the Madras High Court acquitted the accused, stating that the check was issued for the payment of illegal debt, right. So what happened, the trial court convicted, the Madras High Court acquitted, okay, stating that the check was for the payment of illegal debt, okay. So the complainant challenged the order of the Madras High Court and in the Supreme Court, relying on the judgment passed by the Kerala High Court in the C.V. Raman versus Illikal Ramasen case. This is the case of 2015 and the complainant relied on this case of Kerala High Court and they challenged the order of Madras High Court in Supreme Court. So this case of C.V. Raman versus Illikal Ramasen, it declares that if any debt that arose out of an illegal promise, so if any debt is arose out of an illegal promise, it will still fall within the ambit of section 138 of Negotiable Instruments Act. So if any debt arose out of an illegal promise and a check is issued for the debt that arose out of that illegal promise and that check got dishonored later, then still it will fall within the ambit of section 138, okay. And once a check is issued for repayment and it is got dishonored, it will still attract a liability under section 138 because still since that arose from illegal promise, no matter what, it will still attract the liability, okay. This was what was held in C.V. Raman versus Illikal Ramasen case. So the Supreme Court, upon hearing the petitioner, that is the complainant in the case, was not inclined to issue notice to the respondent. Prima Facie observed that the debt in the present case could not be considered as a legally enforceable debt. So to bring action under section 138, because it is not a legally enforceable debt, and to bring action under 138, the debt should be a legally enforceable debt. But the Supreme Court later issued a notice to respondent in order to ascertain the correctness of the Kerala High Court judgment.